we can read CSG benefit, social benefit, 2020-2023, this fiscal year, a budget amount of 2.2 billion rupees. This is the amount which is going to cater for the 1,000 rupees which will be payable to people above 65. So this is for this year. But then in the estimates, for next fiscal year, this estimate jumps to 10.1 billion rupees. And then for 24-25, it is 10.5 billion rupees. So it's already budgeted that as from next year, from 2.2 billion rupees, government is already planning to disburse 10 billion rupees to retirees above 65. And this should not come as a surprise, because when we turn to the same estimates at page 484, this time we're dealing with revenue collection from social contribution, the amount of money which the government has collected under Contribution Sociale Généralisée. Already, for last year, they have already collected 5.2 billion rupees. For this fiscal year, they intend to collect 8.6 billion rupees, and for the next income year, it would be 10 billion rupees. So the mathematics is there. They will take 10 billion rupees from workers and give 10 billion rupees to retirees above the age of 65. So I don't know what is this game about, trying to cause confusion in the mind of people that, next year, if the economy is okay, we will give you money. There's nothing about economy. You've already budgeted for it. It's already there. You have to pay. And may I remind this side of the House that it was their electoral promise that people will be paid, retirees will be paid for 13,500 rupees as pension. Retirees means those who benefit from pension as from 60, not 65 years. Pension payable when they come to power, not 4 years, 5 years after they come to power. And most importantly, they never said to the population that workers will have to pay a new tax, Contribution Sociale Généralisée, to fund that additional retirement benefits. With your permission, I would now like to turn to a subject which I have to confess I don't master at all. And this relates to the proposed amendments to the Gambling Regulatory Authority Act, which was alluded to by the Honourable Leader of the Opposition. Now, these measures were not announced in the budget, was not there in the budget speech, but was alluded to in the annex to the budget. Like everyone in Mauritius, I like horses. And when I was a kid, my father used to take the whole family regularly to Champ de Mars to watch horse racing, in particular the classic, Ducesse, Maiden, Coupe d'Eau. It was a family outing, an entertainment, very much part of our national folklore. Champ de Mars is located in my constituency, and many families in my constituency attend horse racing every week. Some even go every day to the training session to watch in the early morning horses train. They used to speak passionately about horse racing. Many of them earn a living out of horse racing, be it as a stable boy, palefrenier, food hawkers, or even bookmakers. But what this government has done to horse racing in this country is unforgivable. I'm not going to go into the reason why they did it, what grudge they may hold against the Mauritius Turf Club, MTC Sports and Leisure Limited, or its former president. Suffice it to say that after horse racing in Mauritius has been organized by the MTC, which is a non-profit organization, for 210 years, this government has decided to terminate the lease that it held in Champ de Mars and given a license to a newly formed company, the People's Turf PLC, which has absolutely no track record in organizing horse racing anywhere in the world. And the finance bill today, to a large extent, is ratifying what has already been done. For example, the State Lands Act at page 122 of the bill is being amended to allow the minister to vest the control and maintenance of Champ de Mars in the Côte d'Or International Racecourse and Entertainment Complex Limited, a company fully owned and controlled by the government. And no rent and fees shall be paid by this Côte d'Or company. What an irony. What an irony for a party who once had as its main campaign theme at the general election, combating Nation Zougadère. Today in power, this same government, through this Côte d'Or company, has now become a direct participant in the Zougadère culture. Yes, but Côte d'Or is being, the law is being amended, state law, to give the power.
Comment on the amendment.
Yes, I'm commenting. I'm not agreeable that the government now is getting.
Leave apart the policy of
that
the
is the amendment.
Government. Leave apart. Come to the
but
amendment.
That was not spoken in the budget speech. It's only now that we have it in the finance bill.
Don't discuss with me. Discuss with the chamber.
So the Prime Minister is amending the State Land Act, but he has already rescinded the lease. That Mercier Turfclub had over Champ de Mars, and they did so without paying a single cent as compensation, despite the investment made by the MTC over the years, despite the infrastructure bill, despite the monitoring system implemented, despite all the improvement made to the racing track of Champ de Mars. The Gambling Regulatory Act, is being amended to give more powers to the horse racing division when it comes to licensing horse racing organizers, jockeys, and even horse owners. A notable amendment is to the requirement for licensees now to be fit and proper person. But what is odd is the proposed wording in the proposed amendment to section 30, subsection 2 of the Act. It is at page 49 of the bill, and it reads as follows. No horse racing organizer license shall be issued unless B, any of the applicants, directors, managers, officers, or any other person having a direct or indirect interest in the applicant is a fit and proper person. I read this section several times because I was not sure that I was reading it properly. But the plain wording of this section is that no horse racing organizer license will be issued unless any of its directors, managers, officers, etc., is a fit and proper person. Now, this section does not require all the directors, managers, officers, shareholders to be fit and proper person. They only require any. So, in other words, the shareholders and directors of the horse racing organizers can be not fit and proper person as long as any one of them is a fit and proper person. So I really hope that this is not the intended consequence of this amendment, and I will invite the Honourable Member, the Honourable Minister of Finance, to double-check it with the drafting team. Because we're talking about big money here. Big money. According to a report published by Ernst & Young, entitled Economic Impact Assessment of the Mauritian Horse Racing Industry in 2018, the horse racing industry generated 6.2 billion rupees in GDP in 2018. The horse racing industry employed 2,170 people directly and indirectly, and generated some 679 million rupees in government revenue every year. Big, lucrative business. And today, GOA has given, because this is what this amendment gives the horse racing division the power to license horse racing organizers, and GOA has used this power to give a horse racing license to a company owned by a person who not only will be organizing horse racing, but he's also a licensed bookmaker
Now you're
and
departing.
a
You're going
licensed
too far.
owner.
Honorable member, bear with me. You're going too far. Comment on the amendment proposed. Comment on that. Bring it nearer. You are talking of the policy, what the GRA is trying to do, what government is. The amendment.
With you, Mr. Speaker, but what I'm saying here is what everybody knows. Les mêmes propriétaires, les mêmes bookmakers, les mêmes organisateurs, même qu'ils existent.
But this kind of, you know,
and he is the one who financed this party.
this kind of comments are
10 million
controversial,
rupees.
and so you should not be indulged in all this. Continue.
Yes. I'm sorry, but this is what it is. This is what it is. The last amendment, well, the last thing I'd like to comment upon is an amendment to the Civil Status Muslim Family Council Regulation 2005, which is at page 164 of the bill. There are also related amendments to the Social Aid Regulation of 1984 at page 162 of the bill, and amendment to the National Pension Act. This proposed amendment relates to a provision announced in the budget, which I have to say triggered passionate debate by some honourable members on both sides of the House. Let me recall what the Honourable Minister of Finance said at paragraph 457 of the budget speech. And I quote, "We are extending the basic widow pension to Muslim widows through tardy registration of religious marriage before the Muslim Family Council." Unfortunately, this proposed amendment has resulted in comments on the social media and from various persons living in a different era. Allow me briefly to remind honourable members what was the issue. Between 82 and 87, Muslim women were allowed to marry religiously under the Muslim personal law. Then in 1987, the law was repealed and the religious marriage was no longer recognized. So there was a case entered by Mr. Biwa before the Supreme Court, and then all the way to the Privy Council. By the time the case reached the Privy Council on the constitutionality of that amendment, the government amended the law to introduce the Muslim Family Council, which was given the power to register marriages after December 1990. So prior to November 87, all the nikah, religious marriage, were registered. After December 1990, all the marriages were registered with the Muslim Family Council. But there was this gap between November 87 and December 90. We're talking about 3 years. We're talking about very few registered nikahs. And most of the people, the spouses, most of them anyway are either dead or above 60. So in any event, they already are getting the retired pension benefit. So honourable members, during the debate, thought that this government was going to rectify this alleged injustice and recognize marriages, with religious marriages between 87 and 1990. Unfortunately, when we look at the proposed amendment in the finance bill, that is not the case. What the amendment proposes is that those religious marriages which were celebrated before 87 or after 1990, who have not been for a reason or another registered with the Muslim Family Council, in these cases, the spouse is given up to December 2022 to now register that marriage, that nikah, that religious marriage with the Muslim Family Council. But for those who married between November 87 and December 1990, there's still nothing, there's still no avenue, there's still no registration. So I wanted that to be clearly stated in the light of all the passionate debate that we have. But when the Honourable Minister of Finance presents his finance bill, he comes up with a new measure that was not announced in the budget, that was not in the annex, that has never been discussed inside this House or outside the House, and is going to have far-reaching consequences on spouses who have performed nikah. I'm talking about the proposed amendment to the Social Aid Regulation 1984, which is at page 164 of the bill. Today, there is absolutely no difference between a widow who has religiously married or who has civilly married. The law recognizes both, and both have the same right. When their spouse passes away, they are entitled to the same benefit, the same social allowance. But now what this government is doing, when it comes to surviving spouse allowance, Section 18 of the Social Aid Regulation 84 is being amended to read as follows. Where the applicant is one of the surviving spouses of a deceased person, the Permanent Secretary will pay to her a surviving spouse allowance, the amount of which shall, depending on the number of surviving female spouses, be divided in equal proportion to the rate of the widow's basic pension. So now, a widow who has religiously married will not have the same right as a widow who is civilly married. A widow who is civilly married will get the full allowance, full social allowance. But a widow who is religiously married, depending on whether his spouse had 2 wives or 3 wives, she will no longer get the same. And yet, when the husband was alive, she was treated like a full-fledged wife with all rights, being all maintenance, all properly catered for. And after the husband passed away, now he is no longer one person, he becomes quarter of a person, half of a widow. So this is extremely discriminatory. And I hope I'm not reading the law properly, because this provision, social aid regulation, falls under the Ministry of Social Security. And I'm very glad that Honorable Jiwado Yao is on the speaker's list. And I'm eagerly waiting for her to explain to all these widows the rationale of reducing the widow's allowance at a time of high inflation and increased cost of living. Because the Honorable Minister of Finance did not have the courage to state why he is depriving Muslim widows who have religiously been married, as permitted by law, to the full surviving spouse allowance. The finance bill is being debated today at a time where the rating agency Moody's has downgraded Mauritius to Baa3. And despite the amendment to the Bank of Mauritius Act, it is with great regret that there is not yet a word in this finance bill about amending the Bank of Mauritius Act to comply with the recommendation of Moody's and IMF. It's not too late. I'm urging the Honourable Minister of Finance to do the sensible thing at committee stage and amend the Bank of Mauritius Act to reassure Moody's, IMF, and above all the lenders we should not underestimate the gravity of the situation. And it is nothing short of childishness for both the Ministry of Finance and Bank of Mauritius yesterday to issue communiques to self-congratulate themselves for this downgrading. Thank you.
Honourable Ducan.
Mr. Speaker, sir, thank you for giving me the opportunity to intervene on the finance bill. And as we are all aware, it is part of the principle of natural consequences that now that the budget 2022-2023 presented by my colleague, the Honourable Minister of Finance, has been warmly welcomed by the population at large, the measures announced have now to be implemented. Et cela doit impérativement passer par les amendements à certaines législations existantes afin d'activer la mise en œuvre. Aujourd'hui, Monsieur le Président, je me contenterai d'être bref et donc je ne vais qu'aborder les trois aspects du Finance Bill qui ont trait à l'éducation. Mr. Speaker, sir, let me first take the amendment proposed at the Education Act. Indeed, the Finance Bill makes provision for an amendment to this Act with regard to the introduction of a new scholarship scheme on the economic side. You will recall, Mr. Speaker, sir, that at paragraphs 245 and 246 of the budget speech, it was stated that government would introduce the Sir Anirudh Jagnat National Scholarship Scheme. A scholarship would be awarded to the most meritorious boy and girl on the economic side. Mr. Speaker, sir, the Government Scholarship Scheme, also known as the Laureate Scheme, provides for 69 scholarships, including one MCB Foundation scholarship annually. Under the Sir Anirudh Jagnat National Scholarship Scheme, 2 additional scholarships will now be offered for the 2 laureates on the economic side to study for an undergraduate degree, either overseas or locally, and for a maximum of duration of 4 years. The scheme, Mr. Speaker, sir, is a means to pay tribute to the late Sir Anirudh Jagnat. Indeed, the Mauritian population as one recognizes Sir Anirudh Jagnat as the father of the Mauritian economic miracle. Certainly, he had been the driving force behind the economic transformation of Mauritius, and, Mr. Speaker, sir, Sir Anirudh Jagnat had always considered education as the bedrock for social equity and inclusiveness, as well as a leverage par excellence for economic progress. It thus befits his memory that we should attribute to the lead boy and girl on the economic side a full scholarship to enable them to engage in further studies. And I'm fully confident that the scheme will further encourage students to excel in their studies at HSC and beyond. After all, they will forever be motivated to honor the person after whom the scholarship is named, and the awardees would be able to come back and put the acquired knowledge and experience to the service of the country. Nothing would honor the spirit of the late Sir Anirudh Jagnat more. Accordingly, Mr. Speaker, sir, the Education Act is being amended in the first instance to include a new section 33C, with the existing section 33C being renumbered as section 33D. Mr. Speaker, sir, let me now justify the second important amendment. The House will recall again that at paragraph 257 of the budget speech, reference was made to the construction of a new Ayush hospital at Côte d'Or. This was in line with honouring the announcement made by the Honourable Prime Minister at the groundbreaking ceremony of the World Health Organization Global Centre for Traditional Medicine in India. Mr. Speaker, sir, this requires some upstream work and a travail méticuleux en amont has to be undertaken. Illustratively, a hospital, especially Ayush hospital, needs practitioners and specialists in the 6 Indian systems of medicine, namely Ayurveda, Yoga, Unani, Siddha, and homeopathy. all of which are commonly called Ayush. Hence, the Finance Bill proposes major amendments to the Ayurvedic and other Traditional Medicine Act, particularly with regard to the terminology. Thus, there is an amendment in the definition of the traditional medicine, and the words homeopathy and Ayurvedic are being replaced by the words Ayurvedic, Ayush. The other amendment pertains to the deletion of the term practitioner and practitioners and replacing them by the words general practitioners and specialists. Mr. Speaker, sir, one good thing about Mauritius is its openness to new ideas, new ways of doing things, taking to and adapting to them seamlessly. The natural empathy that has led to the acceptance of several traditional techniques and remedies transmitted from generation to generation. One such sector, which is very popular in Mauritius, is the field of Ayurveda, and the other 5 Indian systems of medicine prevalent and practiced in India and some other neighboring Asian countries. As the House is no doubt aware, the concept of Ayush was introduced in the mainstream medical field to strengthen the public health services through the revitalizing of local health traditions. This concept helped in utilizing the untapped Ayush therapeutics, the principles for the management of community health problems at different levels, including the workforce. It is interesting to note that the recent global pandemic brought to the fore the need to find solutions without harming the environment. While the medical sector was battling the disease and faced the pressure of finding a cure or a vaccine, attention also partly focused on natural cures provided by Ayush practices as a means of self-protection. We'll recall the YouTube channels that were rampant with Ayush techniques to maintain a balanced life, including mental well-being when faced with the distress of lockdown. To this end, and to promote the local sectors of operation, government is promoting the use of Ayush by setting up a Center of Excellence for Ayush in Côte d'Or. We want to ensure our population has access to as many techniques and modes of treatment as provided to ensure its healthy existence. And this goes through a formal recognition to Ayush studies. To this end, my ministry gave its blessing to a bilateral agreement between the University of Mauritius and the Central Council for Research in Ayurveda from India in 2019. As a consequence of this fruitful collaboration, the University of Mauritius has been hosting an academic chair in Ayurveda medicine since November 2021. Mr. Speaker, sir, we want to ensure that our population fully benefits from Ayush. It is noteworthy that the Mahatma Gandhi Institute is already delivering a certificate course in Ayurveda and Yoga. Similarly, along with the Center of Excellence in Ayush, the University of Mauritius will be offering undergraduate and postgraduate courses in the field of Ayush. One such program is a postgraduate certificate in Ayurveda Panchakarma for Ayurveda graduates in collaboration with the university's Center for Innovative and Lifelong Learning. As you may be aware, the Panchakarma is a unique method of cleansing the body, and it includes preventive, curative, and promotive actions against various diseases. The University of Mauritius will follow all the required procedures, and the course will be offered with approval of the Ministry of Health and Wellness, as well as the Higher Education Commission. Mr. Speaker, sir, because the conceptual realm of Ayush is relatively new for us in Mauritius, allow me to delve a bit deeper into some of the benefits it will bring. Mr. Speaker, sir, many aspects of Ayush must be seen as opportunities for local higher education sector, but also for the research sector. Mauritius has a number of endemic flora and fauna which have high medicinal properties. Our researchers have done so much already to showcase our rich surroundings. Research in moringa, on the black tea, and their beneficial impact on human body are just 2 such areas. We must not underestimate the rich marine biodiversity that we have. These research areas and such others, Mr. Speaker, sir, would allow for the creation of new opportunities for the business sector as well. Finally, Mr. Speaker, sir, let me conclude by saying that the amendment proposed by the Financial Bill to the Statutory Bodies Pensions Fund Act. This amendment aims to include all secondary schools that receive grants under the Private Secondary Education Authority, that is, all private grant-aided secondary schools. Mr. Speaker, sir, the guiding principles that government has adopted with regard to private grant-aided secondary school sector have been ensuring the prevalence of equity and parity with the state sector, be it in terms of facilities provided to students or benefits accruing to the staff. On the other hand, Mr. Speaker, sir, the Finance Bill, Mr. Speaker, sir, is firstly amending the Statutory Bodies Pension Funds Act to clarify the first point, namely that the term secondary school here implies to those, as I've said, private grant-aided secondary school. Secondly, staff who joined the private secondary schools prior to the 1st January 2013 contribute to the private secondary school staff pension scheme, which is a defined benefit pension scheme governed by the Private Pension Schemes Act 2012. This scheme falls within the purview of the Financial Services Commission and is managed by SICOM. On the other hand, Mr. Speaker, sir, staff of the private secondary schools who joined service as from the 1st January 2013 adhere to the Public Pensions Defined Contribution Pension Scheme, which is governed by the Statutory Bodies Pensions Funds Act. The legislative amendment proposed is primarily serving to align employees who joined the sector prior to the 1st January 2013 with those who joined the sector post 1st January 2013, such that they will all be governed under the Statutory Bodies Pension Funds Act. Mr. Speaker, sir, let me explain the rationale behind this. The private defined benefit pension scheme, by its very nature of being a closed fund, will over time have a reduced number of active members while the numbers of pensioners will increase. As matters stand now, the PSS pension scheme is able to meet its pensions obligations over some 10 years, but has an actuarial deficit. For recall, the actuarial deficit takes into consideration the future benefits payable to existing and future beneficiaries. So it is not a cash deficit, but an actuarial deficit. Accordingly, by proposing that the private secondary schools be listed under the Statutory Bodies Pension Funds Act, we are ensuring that all members of the profession are treated equally. In fact, members will be better off with additional benefits, including new provisions recommended in PRB reports, and this while the acquired rights of members under the existing PSS pension scheme are being preserved. With this change, the actuarial deficit in the defined benefit pension scheme will be addressed. Mr. Speaker, sir, you will have noted that I have centered my intervention around 3 amendments proposed in the Finance Bill related to my ministry, as I stated earlier. So, Mr. Speaker, sir, with this, I thank you for your attention. Thank you.
Thank you. Before you have the floor, I'll ask the Deputy Speaker.
Thank you very much. Please be seated. Honorable Boulay, please.
Thank you very much, Mr. Deputy Speaker. The Finance Bill is an omnibus legislation. And this is a mammoth bill, as has been stated by previous orators, especially Honorable Xavier Duval, leader of the opposition. It's a mammoth bill with 84 clauses and 13 schedules. And I have to register our complaint, and very much like what has been stated by Honorable Xavier Duval, I'm yet also to understand why the memorandum was circulated only on the threshold of the debate. Mr. Deputy Speaker, the bill is being introduced against a backdrop of a global economy which is edging towards a recession, against a backdrop of cost of living which will go up with further depreciation of the rupee and high treason on the domestic front. The latest, of course, is the downgrading of Mauritius by Moody's credit ratings. We are hanging by a hair's breadth, a notch above junk status and on the edge of the cliff. As we say, take the IMF prescription, otherwise go the Sri Lankan way. I hope our economy will not be on a free fall. But there's a price, of course, to pay for economic mismanagement. The regime should not get away, and it is responsible for the devastating impact on commercial banks, and through no fault of theirs, and now de facto below investment grades. Beware of disinvestment. Mr. Deputy Speaker, the devils are not in the details, but on the wall of the regime with bold characters. They are, of course, unintended, deliberate, and intended consequences of the legislation. I hardly notice any policy measure, and many clauses deal with administrative tightening measures when there should have been consequential amendments. Some of the clauses, unfortunately, are tailor-made to enable winners like Mr. Lishim to take all. Notwithstanding that his business escaped tight scrutiny, he is now the lord of Champ de Mars, state land, till or if ever he moves to Côte d'Or. Glory to the political war chest of the centrist. Mr. Speaker, with or without those constantly replenish the war chest of the centrist, the countdown has started, and it's game over for Prime Minister. Let me, after these opening remarks, come to specific clauses. The amendment to the Animal Welfare Act. Yes, they make things tidy, and Section 36 of the Animal Welfare tightens penalties, but enforcement remains the crux. In Section 41, after Part 5, new parts added, namely 5A, to ensure that breeders of animals for competition, pure breed, or leisure have a breeder's permit issued by an officer in charge of the Department of Veterinary Services. But it is easier said than done. Are the breeders registered? Most of them are not, and they have the habits of saying they keep these animals or as pets. Animals cannot be bred in a limited, confined perimeter. It's being done, and there are provisions for offenses. I pray for enforcement. The MSOR certainly remains a real eyesore. And I was told that the Minister of Agro-Industry did make a side visit to Abercrombie, a surprise visit, I was told, and I'm sure he was shocked, appalled, and flabbergasted to take stock of cruelty inflicted upon the dogs. They say that strong dogs were making a meal of weak dogs, and that was the reality. My first prayer, which is yet to be answered, is neutering of stray animals and a campaign for proper catching should be the last, and as a last resort, disposal of animals. Vicious campaign has been waged against Mauritius, considered by many as a destination of cruelty to animals. I know of tourists, especially from UK, who have adopted stray dogs and become part of the family. Mahatma Gandhi, the apostle of nonviolence, advocated this policy towards animals, protection of the sacred cow. Mr. Deputy Speaker, the Finance Bill does not address the reform required to make the Bank of Mauritius fiercely independent. As I say, no one can ignore all the recommendations of the 2022 IMF Article 4 consultation mission. The Minister has promised that the Bank of Mauritius will no longer be the ATM of government. It will be decoupled from the MIC, and unused funds will be returned to the Bank of Mauritius. The Minister of Finance, in a reply to a PQ asked by Honorable Ramphal, promised redress and highlight the independence of the Bank of Mauritius. The amendment to the Banking Act for approval of a license to the applicant will be void if terms and conditions are not clearly spelled out. As may be determined, is neither here nor there. Uncertainty will open the door for the likes of Ketan Somaya, the Sukon, and the Sobrino. We paid a heavy price by looking at Sobrino in the eyes. King Kong Ketan Somaya, jailed in UK for multi-million fraud. And the banking license to the free operators were issued when the MSM was in power. We say no to shades of grey and yes to transparency. Mr. Speaker, let me now come to the pension scheme and civil service family protection scheme and their intended consequences. Now, I thought I was the one who was targeted, but then I was told that since I make a contribution of 4% of the wages which I'm entitled to, it's going to target those who make a contribution of 2% of their wages. And even then, it's discriminatory. I hope the minister will take corrective measure, because this is not only discriminatory, but it is anti-constitutional. Mr. Speaker, the law may be an ass, or is an ass, but it cannot deprive a citizen of a return on his contribution. I recall that the regime of Sanaru Jagannath wanted to compulsorily acquire the residence of Kishore Deepal Singh because he was a dissident MP. And if it were not for Sir Satkham Bulel, the then regime would have gone ahead with it. The matter was discussed in the Council of Ministers. If the Honourable Minister wants to review pension, and if the review is part of a balancing act of risk and rewards, at least he has a responsibility to tell the public. Let me come to the pension schedule for year 2023 or 2024. This has been well ventilated that it will be implemented in June 2023. There is a confusion, though. I don't know whether the confusion was deliberately triggered in the light of an article which appeared in a daily. Is it linked to the outcome of the case entered by Petitioner Dial to contest the seat of the Prime Minister in constituency number 8? I hope that they will not find excuses to reschedule full pension payment to those who are 65 years old, those who are 65 years old, and that the schedule payment is made in due time as promised. Mr. Deputy Speaker, it was, as I said, spelled out loud and clear by Prime Minister and Minister of Finance that monthly pension payment of 13,500 rupees would be effected as from July 2023. With constant depreciation of the rupee exacerbated by downgrading of credit ratings to a notch above junk status, the outcome will be light featherweight pension scheme. And to prepare for a graceful retirement, state employees are bound to contribute to a pension scheme. In Clause 31, there is provision in Section 27DB to increase the contribution from which they would be entitled to from 30,000 to 50,000 rupees, the maximum allowable deduction in respect of contribution made by taxpayer to a personal pension scheme for the provision of a pension for himself. But for God's sake, I expect the minister to come clean and spell out very clearly commitment given in respect of pension or payments which should be effected in July 2023. Mr. Speaker, Deputy Speaker, with an aging workforce, we are already in the doldrum. Contribution for one eligible pensioner will be drawn from a workforce of 2.4 persons. It is a scheme which will run out if fundamentals are not addressed. I hope we will not be an IOU nation. Let me now turn to clauses relating to agricultural sector. Clause 26 is being amended to empower Food Agricultural Research Extension Unit to do what its objectives are. Emphasis on research work in the non-sugar sector. But again, it's like bursting an open door with a butt from the head of a ram. Agricultural sector and agro-industry, I would ask the minister, unfortunately he's not here, where are the findings of the latest report of the opportunities in the non-sugar sector? As to self-sufficiency staple commodities like potatoes, onions, I would say, Mr. Deputy Speaker, it remains a forlorn dream under this government. The Minister of Agriculture of Agro-Industry should define policies to prevent encroachment on prime agricultural land. And there's an urgent call for clear demarcation line on land use and planning. Land under forestry is a bare minimum. Forestry is a good carbon dioxide cleanser, but there's a call for reforestation. And if we have to reach and meet our commitments given by the Minister of Environment on mitigation and adaptation target by 2035. Our biomass framework is yet to be subject of wide discussion with stakeholders, and the price should be indexed on heavy fuel oil. Mr. Deputy Speaker, only the price of bagasse has been determined, but still on the low side. I hope justice will be done to the planters. Clause 39, the Mauritius Agricultural Marketing Act amended. I ask myself, what is the purpose when the object of Agricultural Marketing Board is an importer and buyer of last resort? There is a call to revisit the objectives of AMB to make it more responsible to consumers, wholesale buyers, and sellers. Let me come to the Mauritius Cane Industry Authority, which is being amended. I'm glad that the Mauritius Cane Industry Authority has spared the sugar syndicate and has not ripped off its membership from the International Sugar Organization. You may recall I made a strong plea during my intervention in the debates on the budget not to disrupt a system which is delivering. As we say, never repair if it's not broken. And there is a sacrosanct relationship, and it gives a marketing leverage to the Mauritius Sugar Syndicate. Clause 26B of the Mauritius Cane Industry Authority in Section 24 to exempt producers and sellers using small tonnage of cane for production of cane juice for direct consumption from requiring the approval of the Minister of Agro-Industry. The ultimate beneficiaries are the miller planters who have a cluster with value addition, and they will use a sizable amount of the cane juice to be processed at their refineries. There will be an impact on the tonnage of sugar production. It's a choice, but the interests of small planters also have to be safeguarded. By deleting the and O, there is no obligation then on big planters to send a specific volume of tonnage of sugarcane to the mill. How big is the small tonnage of sugarcane to be earmarked for cane juice? This is yet to be spelled out, and I expect the Minister to inform the House. Now, I grant you, Minister, it is an administrative burden. There is a niche market to capture, and our sugarcane juice rum, of course, is much sought after. As you say, it toast to the spirit of the planters, but fair and reasonable price to small planters who will send the cane juice to the bottlers. Mr. Deputy Speaker, the Sugar Industry Efficiency Act is inevitable, as the Minister did not even have an iota of oversight on the Sugar Investment Trust, which has become unworthy under this government. Time for amending. The amendments make the Minister the master of the trust, and I expect he will not exercise undue pressure, but will allow the trust to deliver. Oversight, yes, but no stronghold. A vicious campaign was waged to provoke the departure of the CEO of SIT. He was wrongly accused of providing information to the opposition on the financial irregularities in relation to Water Park. He was unfairly accused of providing information to the opposition, and yet he had to put the SIT, and yet, he was the one who started to bring reform to make the SIT more workable and more responsive to the needs of its members. Unfortunately, the board has been operating without the CEO since the end of June, and the SIT has been taken over by one board member, allegedly representative of small planters, and it has a stronghold over the 5 elected members. I hope the Minister acts diligently and do not repeat the mistake made over the appointment of 2 members on the board of the Sugar Syndicate. They are not even representative of the Federation or Association of Sugarcane Planters. The planters who are members of the Federation feel aggrieved over the nomination of 2 non-members on the board of the Sugar Syndicate. The board of the SIT will be newly constituted, and may I remind the Minister, any departure from sound management, that is accountability and transparency, will blow in his face. Today, the SIT is a losing concern, and I expect it to come with a restructured plan to make a U-turn and to be profitable trust and eventually pay dividends. Mr. Deputy Speaker, let me now come to Sugar Insurance Fund, C50A, clause 50B, clause 50C. Now, normally all these amendments are being revised after an actuarial exercise has been carried out, following representation by Association of Planters. This is the due process. By amending Section 2I of the Sugar Insurance Fund Act, in definition of normal years, by deleting the word 8 crop years and replacing it by 5 crop years, planters stand to lose. The crop is insured on the average of the 3 best years out of 8 years, which give them a better insurable tonnage on average. The Minister needs to find time and interface with the planters community to address the long outstanding issue. Let me now move from cane field to horse racing. The changes to the horse racing related section will further increase the interference of the Gaming Regulatory Authority Board in the matters of horse racing organization. I'm referring to the amendment F and G, which correspond to Section 30 and 31 in the GRA Act. Why does the Gaming Regulatory Board concern itself, and the question has been asked, with horse racing matters when there is a horse racing organizer? Amendment H relating to Section 33, fees payable by the gambling operators to the horse racing organizer. Once again, the board is determined, and the way it's acting, the board is determined on killing an industry that provides a living to so many people. Over 10,000 people live from racing directly or indirectly. Was the horse racing division under the GRA board? And if it is so, and as it is, the horse racing division is under the GRA board, therefore the GRA is acting as judge and party in horse racing matters. There is no clarity on the number of horse racing organizers and what are the criteria for a horse racing organizer to be awarded a license. Has there been a public call to invite those willing to apply for a horse racing organizer license? As we say, there's only one winner, and it's Mr. Lissim. Is there a commitment to evaluate the application?
Honorable President, it's not proper to take the name of somebody who's not in the parliament. You withdraw it. I think it's quite fair.
Reading, but
Thank you very much.
I'm stating fact. Thank you very much. Now, let me come to laboratories. Why source out other laboratories for blood sampling? The minister will have to tell us. And can the minister provide which countries, the logistic that will be involved, and the cost, the duration to receive the results? What will happen to Quantity Lab, which carry out those tests? Mr. Deputy Speaker, following the case won by a gentleman, I won't drop the name, HT, regarding the operation of limited payout machines, will he be allowed to operate? Same. I hope so, because he has won his case. The ruling was in his favor, and I expect that he will be allowed to operate. After seeing seals affixed to its gambling machine, the HT Investment Company Limited, as I say, won the case before the Supreme Court. Now, the judgment was pronounced by the senior punitive judge and Judge Benjamin Marie Joseph. Now, but unfortunately, there's only one limited machine operator, namely SMS Parias Limited, and it obtained its license in May 2018. So there's been a court ruling, a ruling that has gone in favor of this gentleman. I hope that justice will be made, and he will be entitled, certainly, to operate the gambling machines. Now, the Gambling Regulatory Authority Act amended the Gambling Regulatory Authority Act, and therefore the horse racing organizer means a public limited company set up with the object of organizing horse races in Mauritius. In Section 2, by deleting the definition of the horse racing organizer and replacing it by the following definition: horse racing organizer means the holder of a horse racing license. The amendment number A, bracket 3, the lottery implies the regulator will regulate promotional lotteries being conducted online via the internet. However, does the promotional lottery amount to internet betting? Is internet betting being allowed? These are relevant questions that need to be answered, and it seems that everything is lopsided in favor of the gentleman whom I mentioned. Mr. Deputy Speaker, till date, we have to remind the House that the GRA issued a tender to appoint a management company to set up the rules governing internet betting activities. Of course, we have to know what is the status of this tender and who was appointed. Let me conclude by referring to the Medical Council Act being amended. in relation to registration of those who have graduated or are going to graduate from the University of Mauritius and would be entitled to temporary registration. Now, then they will have full registration. But let me make an appeal to the Minister to see to it that there is a differential treatment, and that should be extended or given to Mauritian doctors. And for those foreigners who are here working in hospitals, but who have a full registration, may I appeal to the Minister that there should be on a limited registration, as is currently being done in many countries in Ireland and UK. The Pharmacy Act, yes, we welcome the amendment being brought, but there are lessons to be learned and drawn from allocation of contracts. I'm not going to go into the high-perform saga in respect of quality, potency, and price of drugs purchased. In the past, we used to have a manufacturing plant, which used to manufacture drugs. And I'm sure some of us would recall that the drugs manufactured were of poor quality. Forget about bioassay, forget about the relevant equipment which should have been available, forget about samples which should have been assessed elsewhere. But you know, I recall there was an MP who brought a glass of water, purchased one of those drugs, and it was supposed to be a soluble drug, drop it into the glass of water, but it never dissolved. So my appeal to the Minister is to take all necessary precautions, to err on the principle of caution. It's all right to bring amendments to appropriate legislation, but at the end of the day, we have to deliver. If we want to be a brand name, and if we want to be a destination of repute, and if ever there is room for export of drugs, we cannot be termed as laggards. Either we act professionally, we bring in those who have the acumen to do the job, because at the end of the day, visibility and tangibility matters. I hope the Minister will respond to some of the questions I've put, and I'm sure that the finance bill, though many of the clauses in the bill are for administrative purposes, but there are some issues which have been raised, of fundamental issues, in relation to the right of an individual of a Mauritian born, man or woman, who are equal before the law, but there cannot be treatment which go against this equality. Before the law, we're all equal, and I sincerely hope that in relation to the widows who married under the Family Council law, certainly rights and obligation will be complied with. At the end of the day, we have to make sure that we are all equal. Thank you very much.
Thank you very much, Honourable Minister.
Yes, thank you, Mr. Deputy Speaker. Thank you for giving the floor to address the House tonight on the Finance Bill. The introduction of the Finance Bill makes provisions for amendments to various legislation to support the implementation of the measures announced in the budget. Let me, Mr. Deputy Speaker, start with the increase in pension for persons aged 65. Now, for those aged 60 and above, they have already been paid the increase in basic retirement pension of 1,000 rupees by my ministry. So their pension has now been increased from 9,000 to 10,000. Clause 67 of the Finance Bill is proposing to amend the Social Contribution and Social Benefit Act 2021. So a retirement benefit of 1,000 rupees will be paid to persons above 65. So they will now be paid a pension of 11,000 instead of 9,000. subparagraph 3A of Part 3 concerns Social Contribution and Social Benefits Act, that is the disability allowance. A disability allowance of 2,500 will now be provided for persons suffering from a disability of between 40% and 59%. As we know, Mr. Deputy Speaker, so far only persons suffering from a disability of 60% or more benefit from the basic invalidity pension. Those with a disability of less than 60% are not eligible to any disability allowance except for social aid. Social aid, we know, is means tested. As such, not everyone can benefit from it. So in a spirit of fairness, we have thought it well. We have broadened the category of persons with disabilities who will benefit from a financial assistance. So which categories are we talking of? Part 1 and Part 2 of the 6th schedule provide us with a list of the type of disability which will be covered. So Part 1, loss of arm at elbow, loss of arm between wrist and elbow, loss of hand at wrist, loss of 4 fingers and thumb of one hand, loss of leg between knee and hip, and loss of leg between knee. We have given, Mr. Deputy Speaker, we have given priority to persons who suffer from loss of any member. We have had to decide who are those who would benefit the disability allowance as their health would not improve at all, whereas when we talk about non-communicable disease, it is likely to be treated and cured in some cases. Now, Part 2 refers to persons suffering from paralysis of the whole limb with some movement, and paraplegia and hemiplegia with some movement, and grand mal epilepsy. The persons with disabilities falling under Part 1 of this schedule will benefit from the disability allowance on a permanent basis, so they will not have to come on the board each and every time. So this is, I must say, a significant step forward. Those under Part 2, which I have listed earlier, will benefit from a disability allowance for a period of 2 years, which of course is renewable, but they will have they will be called on the board and they will have to be examined. So as you can see, Mr. Deputy Speaker, we have tried to the best of our ability to ease the hardship of disabled persons by providing them with assistance on a permanent basis as far as possible. I'm sure that these two parts of the finance bill mean a lot to persons with disabilities. Now they know that some kind of assistance, some kinds of support is there for them. Of course, we need to put in place a proper mechanism for assessment. I'm here referring to page 116 of the finance bill, clause 30A, 3A. So the finance bill makes reference to section 33 of the Social Contribution and Social Benefits Act and section 34 of the National Pensions Act. Section 34 refers to assessment and determination of claims under the National Pensions Act. So all applications will be assessed by the medical board, provided that the application is accompanied by a medical certificate attesting the medical condition of the person. Another amendment being brought to clause 50 of the finance bill concerns the refund of the recycling fee under the National Savings Funds Act. Recycling fee, Mr. Deputy Speaker, is usually paid at the time of retirement where the money has not been used to pay transitional unemployment benefits. Some persons, however, retire at the age of 60. They have to wait until 65 to be paid. So again, in a spirit of fairness, to be fair to them, we have decided to refund the recycling fee as from the age of 60 instead of 65. So a survey has been carried out at the level of my ministry, and it was found that around 135 persons who have reached the age of 60 will now be paid the recycling fee. Now, let me now touch upon an important amendment. Honorable one member on the other side, Honorable Reza, has talked lengthily on it, the tardy registration of Muslim religious marriage. So before coming to the tardy registration of Muslim religious marriage, let me say a few words on the basic retirement pension and the basic benefit under the CSG. Now, I think the Honourable Member should differentiate between basic retirement pension and retirement benefit under CSG. Under the National Pensions Act, basic pensions are paid as from the age of 60, while under the Social Contribution and Social Benefits Act, payments are made on retirement age of 65. For me, this differentiation is very important when we talk about the amendment which we are bringing in the finance bill. Now, to reply to the Honourable Member on Muslim widows' pension. The Honourable Member mentioned that there is no avenue for Muslim widows religiously married between, if I have heard you well, between 1987 to December 1990. You said there is no avenue for those married between 1987 to December 1990. Well, it appears that the Honourable Member does not know there has been changes. Widows married between 1987 to 1990 are benefiting from the surviving partner's allowance. There is a remedy. They are being paid the surviving partner's allowance, which is of the same amount as the basic widow's pension, so they are deriving a benefit of 10,000 rupees now. So this period has been taken care of. I will urge Honourable Member to go and check, and then we can discuss at a later stage. So for me, there is no qualm. These periods has already been taken care of. Now, another issue. The Honourable Member is comparing a widow who is civilly married to a widow of a religious marriage. So it seems that Honourable Member wants to convey that we are discriminating against Muslim widows. Not at all, Mr. Deputy Speaker, not at all. He even said that we are not recognizing them as widows. But in fact, this is what we are doing. I strongly disagree with the Honourable Member. We are neither discriminating nor refusing to recognize them as widows. In fact, we are the one bringing amendments to make sure that they are acknowledged as widows and they are given their rights as widows. On the contrary, you are the one who have done nothing for years. You have had the opportunity. Some members have been in Parliament for 10 years. So, what have you done? Tell me, what have you done? You have been in Parliament 10 years. And now you are saying that we are doing not enough. So be serious. At least acknowledge the effort of our government. The reality, Mr. Deputy Speaker, is that nothing, I repeat it, nothing was done by any government before us for years, Mr. Deputy Speaker. Mr. Deputy Speaker, believe me, discrimination is not the doing of this government. Mr. Deputy Speaker, discrimination is the doing of the members on the other front. So it is very unfair to come to this chamber and say that, you know, we should have done this, we should have done that, but you have done nothing for years. Some Muslim widows were not eligible to the basic widow's pension due to non-registration of their religious marriage with the Muslim Family Council. I repeat it again, no government has dared to touch upon this matter. In fact, it is an issue which arose. It is not an issue which arose yesterday. It is a matter which is there for some years now. Same as you remember, Mr. Deputy Speaker, same as the basic invalidity pension, which was denied to children with disabilities aged less than 15 years. I think all members of this House remember this injustice. So we did correct this injustice in 2016. Same as the basic invalidity pension, where, you know, some children were deprived of their pension because of an age criteria. So we understand the concern of the Muslim ladies. Our Prime Minister has shown very strong will to correct this injustice. And through the finance bill, we have put, I say clearly, we have put the interests of Muslim widows at the heart of our decision. At least acknowledge that our government has had the courage to address this issue, which has been left unattended for years. Mr. Speaker, I must say it has not been an easy process, you know, to be able to bring this particular amendment. However, we did not give up. It is, I can say it in the chamber today, it is something that has bothered me for personally. What we need, Mr. Deputy Speaker, is action, not talking. So I did sense a particular urgency in coming up with an action to address this particular issue. So first and foremost, we have had to understand the whole issue. And believe me, Mr. Deputy Speaker, it is a very, very complex issue. You know, because some years have been taken care of, some years have been left unattended. So some spouses have been married, some spouses have more than one spouses. So very complex issue. So first and foremost, we have had to understand the whole issue. Then I started discussions, consultation with the Prime Minister's office, the Prime Minister, the Ministry of Finance, the Civil Status Office, and the Muslim Family Council. So following these working sessions, we have been able to work out an amendment to address the hardship of Muslim widows in the finance bill. Now, to enable the tardy registration of Muslim marriage, amendments are therefore being brought to the National Pension Act and the Civil Status Act at page 93. Regulations 4A is being introduced in the Civil Status Muslim Family Council Regulation 2005. These new regulations will allow the surviving female spouse of a Muslim religious marriage celebrated between 1st January 1982 and 13 November 1987, and between 1st December 1990 and 31st August 2022 to make an application to the Muslim Family Council for the Tadi registration of her marriage. All applications for Tadi registrations have to be made in a prescribed form not later than 31st December 2022. We have had to include a cutoff date. Now, once the Muslim religious marriage celebrated during the above-mentioned periods are registered with the Muslim Family Council, the widows can make an application to my ministry for a surviving spouse allowance. In this respect, an amendment is being brought to the National Pension Act for the introduction of a surviving spouse allowance under a new section 4A. Applications for a surviving spouse allowance would have to be made to my ministry in a prescribed form within 3 months of the date of registration of a religious marriage. The application must also be accompanied by a certificate from the Muslim Family Council certifying that the religious marriage has been registered. I, however, wish to mention that where a person contracts a civil marriage and a Muslim religious marriage with one female spouse and also contracts a Muslim religious marriage with other female spouses, the Muslim Family Council will only register the religious marriage with the spouse to whom he is civilly married. The other Muslim religious marriage cannot be registered with the Muslim Family Council. So, furthermore, it is good to note that our government has gone one step further with respect to registration of religious marriage. We are bringing amendments to the Civil Status Muslim Religious Council Regulations 2005 to extend the deadline for registration of religious marriage from 7 days to 21 days. So, Mr. Deputy Speaker, I am happy that for the finance bill, the situation is being resolved and I think to believe something is to make it happen. So, one second.
Take your time.
Yes. Now, Mr. Speaker, with regards to the division in equal proportion among the spouses, well, we have adopted, Mr. Deputy Speaker, dividing in equal proportion among the spouses the allowance is nothing new. So we have had to work out a proper mechanism. So we have adopted the same principle as for the payment of contributory widows' pension. So according to there is a regulation. So according to regulations 7A and B of the National Pensions Contributory Benefits Regulations 1978, where a man dies and leaves 2 or more widows, the contributory widows' pension should be equally divided among the widows. So we have had to work out on a proper mechanism to be fair to all, to be fair to all widows, in fact, in the country. So we have thought it proper to apply the same thinking. So, Mr. Speaker, for me, this amendment is something very close to my heart. I am happy that on this side of the House, we have been able to address it and to address it properly and see to it that those Muslim widows are now recognized. So, Mr. Deputy Speaker, now let me come to clause 65 of the Finance Bill 2022. Section 62E of the Social Integration and Empowerment Act is being amended by inserting after the words financial aid the words excluding the invalid basic pension under the National Pensions Act. It is good to highlight that as the law stands now, all income and social transfers derived by a household are taken into account to determine the eligibility of an applicant under the Social Register of Mauritius. So, as such, even the basic invalidity pension, which is provided mainly to meet the medical expenses of a person, is calculated as an income. So, in my view, this is not fair because we all know that this invalidity pension is not used by people to upgrade their standard of living. As such, they were being left out of the system. We cannot deny financial assistance to someone just because he's deriving a basic invalidity pension to meet his medical expenses. So some things need to be done. So again, I'm happy that now we will exclude the invalid basic pension to determine the eligibility of an applicant. So with the amendment to the Social Integration and Empowerment Act, the basic invalidity pension of 10,000 rupees will no longer be calculated as a source of income when assessing the eligibility of an applicant so that he can be on the Social Register of Mauritius. Now, through the Finance Bill, to conclude, Mr. Deputy Speaker, through the Finance Bill, we are translating all the measures announced in the budget 2022-2023 into reality. All these amendments show that the welfare of our citizens is at the center of all our government's policies and programs. We have made a commitment to our people and we are doing our best to honor it. I have no doubt that with hard work, dedication, the government will surely be able to provide a better future to our citizens. Of course, now with the voting of the financial bill, the smooth implementation is the most important part. I'm confident that each and every ministry will see to it that all the measures announced in the budget are being fully implemented. Thank you.
Thank you very much. We'll break for 1 hour.